proceedings by the court. It's been an interesting morning. There was an earlier recess which was taken when the Speaker's lawyers objected to a member of the five-member panel, Justice Ernest Jewu, being a part of the five-member panel which had been enlisted to listen to the Speaker's case. The Attorney General, Godfrey Yeboah-Dame, as well, raised objections to two paragraphs in the Speaker's affidavit, making the argument that it was disparaging of the Supreme Court. And we know that the court took a recess to particularly hear that objection by the Speaker's lawyers and returned with a verdict that that objection had been dismissed. Let's take you to the court right now. Joseph Akable will join us any moment from now. It does appear there's a challenge with the network at this particular point in time. But Joseph has joined us right now. Joseph, an interesting morning up until now, the afternoon, where we've been hearing arguments back and forth. Let's start off with when the case was called and what were preliminary objections by the Office of the Attorney General to portions of the Speaker's affidavit and the subsequent decision of the justices.
And so that objection has to do with parts of the affidavit that was made available to the court by the Speaker of Parliament, specifically paragraphs 21 and also 49. Now, those two paragraphs, 21, for instance, talks about this whole issue about the service of the processes that were filed in court on the Speaker of Parliament. You recall the Speaker of Parliament had indicated that he had reached an agreement with the Chief Justice for such service to be done on Mondays. Now, the point that was made in the affidavit filed by the Speaker of Parliament was to the effect that the Chief Justice was well aware of the fact that the current case that was filed by Alexander Martin was done unconstitutionally to the agreed process of service. And so that was the first objection that the Attorney General raised, that was scandalous in that it raised allegations against the Chief Justice having knowledge of an unconstitutional conduct. So that was it in respect of the paragraph 21. For the paragraph 49, it had to do with comments that have been made that, look, if the court does not set aside its decision, it risks creating the impression that it's being engaging in a political tool or being used as a political tool to achieve certain ends. That was some of the objection that was raised by the Attorney General, Godfrey Yeboah-Dame, who took the view that, look, those are matters that are serious in nature and the allegations that should not be contained in such a request being made to the court. A lawyer for the Speaker of Parliament, represented by Thaddeus Chori, justified those paragraphs, saying that they have basis in the facts of the case. They said that, look, they have a charge exhibits that shows that the Speaker of Parliament and the Chief Justice have come to an understanding of how such processes should be served on Parliament and the Speaker of Parliament. And so if they make reference that the Chief Justice who is presiding over this case was aware of that particular process, then there's nothing wrong with making such allegations or such statements in the affidavit. In respect of the issue about the politics, they make the point that, look, the court in its decision took notice of the fact that the decision by the Speaker of Parliament has the potential to affect how Parliament has been made up currently or has been constituted. And so that amounts to some political matters that have been put forward to the court by lawyers for Alexander Martin. And so again, the point was made that, look, that is what formed the basis for the conclusion that if the court fails to set aside its decision, then it will mean that it is participating in this political issue that is being raised and will feed into that perception that is being advanced even beyond the courtroom. And so those were the matters that were canvassed. The first part, and our viewers who have been following this coverage, the first part of the hearing, when the court returned, the court did not deliver a ruling in respect of that matter. It says that it was going to incorporate its ruling on when it decides the substantive request, which has just gone on recess to decide, and that is the question of whether or not the Speaker of Parliament's decision, which has been suspended by the court, should be allowed to stand, or the court's suspension of that decision remains in force. Marina.
The second matter which occupied the large parts of the morning, which had to do with an objection by the Speaker of Justice Ernest Jewu being a part of the panel. That objection was raised. The court went on recess and returned with a verdict which dismissed the objection. What were the basis upon which the justices dismissed that particular application?
So, in respect of the decision that was read by the Chief Justice, she did indicate that The process for the appointment is such that the individual is nominated, goes over to Parliament, is vetted, and after vetting, is cleared and takes his seat on the Constitutional Court and the Supreme Court for that matter. And the point the Chief Justice makes is that when the individual has been vetted and approved and has been sworn in, it is presumed that that person is competent, is impartial, and has the mandate to hear various cases, including constitutional matters that have come to the Supreme Court. The court again says it takes judicial notice of the fact that it has within its ranks former, and the rank of the judicial service for that matter, former member NDC parliamentary candidate in its ranks. We also have a former PNC general secretary in its ranks as well, and so that does not affect their abilities to hear that matter. And so the court dismissed the request that Justice Enegei refused himself from this particular matter. He is one of 5 judges here in this particular matter, Marina.
And for viewers watching at home, we've put up the 5-member panel, the list and the names of the individuals on the screen right now. Justice Ernest Jewu is the last from the bottom. He is the individual who the Speaker's lawyers had raised objection to. And so you see the Chief Justice Gertrude Tokon, who is chairing the panel, Justice Mariama Owusu, Justice Samuel Esiedu, Justice Ernest Jewu, who became the subject of debates and objection, and then Justice Yauda Kwasare. But Joseph is still with us from the Supreme Court. And so they are on recess now. There's been arguments advanced by Thaddeus Sorry on behalf of the Speaker. There's been subsequent responses from Abedu as well as the Attorney General, who've all opposed him. Walk us through briefly these points of argument and the subsequent rebuttal by counsel for the Speaker.
Well, so the Speaker of Parliament's position is very simple. As far as they are concerned, they believe that the Supreme Court was wrong on October 18 when it decided to suspend the hearing. They make the point that, look, the matter that was put before the court was alien to the procedures of the court, in that there was not a proper ruling of the court, so to speak, or even a request to be made to a court to suspend any such decision. And so they made the point that, look, that decision was not even something that could be executed. We heard from the lawyer for Alexander Fredemark and Patricia Abedu, who made the point quite strongly that the process that they have followed in terms of the Constitution and Article 2, the Supreme Court has the mandate to issue orders and without any limit to any individual whom the court believes that has engaged in any conduct that is contrary to the Constitution. The Attorney General took a similar position too and made the point that, look, as far as he is concerned, the court have heard time and again. He made reference to cases from as far back as the late 70s to say that the Supreme Court has always decided that it has the power to issue orders affecting every individual. And he makes the point that even the president of the land can be subjected to the orders of the Supreme Court, provided an individual is able to demonstrate that the third impugn action borders on an act that is contrary to the national constitution. And so those were the arguments that he made. But the sorry then came in to briefly make the point that, look, again, the courts have held time and again that when an individual files any process and you realize that there are fundamental concerns with that particular process, you are permitted to approach the court in whatever way or whatever form, advance any arguments to draw the court attention to their regularity or attorneys with those processes. And that was the part of the submission that our viewers may have seen in the latter part, where he makes the point that those are elementary things. He used elementary almost 4 times to make the point that these are matters that should be known. And it's the reason why the Speaker takes the view that the Supreme Court was wrong in this October 18 decision and ought to set that particular decision aside now.
Briefly, they are on recess now. Any idea, really, based on the arguments that's been advanced, how long this recess could take for a possible ruling by the court in determining the way forward? Because a lot of things depend on this ruling today and whether or not Parliament will be able to effectively conduct its business.
I mean, we do not expect this to be too long. The reason is that in the initial application that were done, we realized that the court did go on recess. So what happens is that when the court goes on it, a new panel comes. I mean, unfortunately, we can't show our view of that particular panel because those panels cover those panels. And so once the new panel comes in, then the matter is on hold. And like, when it comes to the end, they delivered lunch. When they were going on this way to this, say that the Chief Justice did indicate that another panel was going to come in to hear the case. Then when that panel is done, they will come back and certify it. So for now, it's all dependent on how long the crunch time for the hearing of the case is done. And we expect that once they are done, and the judges are done considering the arguments, we may have a ruling take place. More often than not, if something that they can deliver a ruling ready, they sometimes take days to deliver the ruling. But this time around, the court has indicated that, look, a panel is coming in, and afterwards they will come back to deliver the ruling.
All right, Joseph, thank you for those details. That's my colleague Joseph Akable with exclusive details for us in relation to proceedings from the Supreme Court at this particular point in time. We'll return to him again as and when the courts or the panel, the 5-member panel, returns with a decision and take you live to the courts as well. But right now, there's still important matters in relation to Parliament Committee. Absolutely. This afternoon, we are learning that the Public Procurement Authority has rejected a request by the legislature to use single-source procurement method to engage SORI at law on retainer basis to support their work. The December 2022 rejection by the Board of the Public Procurement Authority comes as Parliament is defending the Speaker's decision to declare some 4 seats vacant. I want to show you a bit more details from that parliamentary request and the response from the PPA. Now, the decision by the board is that it rejects the use of single source to engage SORI at law as external solicitors. That was the request that Parliament had made on the PPA. The request detail includes the fact that SORI at law will be retained at 5,000 cedis and specific fee for constitutional cases in the Supreme Court not exceeding 300,000 cedis. The Procurement Board, Procurement Authority Board indicated that the reason for the rejection is because they believe the Attorney General is the principal legal advisor and could provide the services that Parliament is looking for from SORI at law as far as its legal matters are concerned. Details from the Public Procurement Authority's response to Parliament, where they indicate why they are rejecting that matter. But what does the law say on this? The Supreme Court has ruled in this matter before, and this is what it said, that with regard to the judiciary and the legislature, where their position on an issue is in conflict with that of the Attorney General, they may proceed on their own by counsel of their choice. However, any of these bodies referred to may access the services of the Attorney General if they do so. Now, in that case, Amegache versus the Attorney General, Justice William Atuguba was the one who made this comment.
So the next thing is an argument of the Attorney General, which proves that he's entitled to.
Indeed, but there's a bit more on this. The question now will be whether or not the Attorney General and the Speaker of Parliament or Parliament are on the same position as the Supreme Court ruling in the Janet Amegache versus AG case are concerned. Remember, the ruling says that if the Attorney General and the legislature are not on the same page, then they may proceed to get their own counsel of choice. Now, let's find out whether or not the AG and the Parliament or the legislature are on the same page. Now, I'll tell you something. It says that respectfully, the words seek to remain in Parliament provide ample clue that is the situation of an MP engaging in acts with a consequence in the life of the current Parliament, which is prohibited by the Constitution and which will result in a vacation of seats. And that's the Attorney General's position on the, the vacation of certain seats in Parliament. He goes on to say that the purpose is to prevent clear abuse of the mandate of the people given to an MP, taking into account relevant considerations like the political party the candidate represented or his independent status at the time of election into the current Parliament.
Again, he adds that it is intended to prevent the cross-carpeting scenarios as have occurred in the constitutional history of this country, particularly the First Republic and in the early years of the Fourth Republic. The Attorney General then concludes to say that in our submission, a person who has filed nomination to contest a future parliamentary election only serves notice of his intention for the future and not in the current parliament. And obviously, this answers the question as to whether or not the AG and the Speaker of Parliament or the legislature are on the same page on this, for which reason they would require to retain Thaddeus Sori or Sori at law to be able to engage in their legal matters, for Parliament. And hopefully that answers the question, because then the AG's position is that the intention is not in effect for this Parliament or the current session of Parliament, but for the future Parliament. The Speaker, on the other hand, believes that the seats need to be vacated as he has announced, and that is why the matter is at the Supreme Court at the moment. We'll continue to give you more on this story as we await the Supreme Court to return from their recess. Right now, I want to take a quick break. When I come back, we'll bring you more stories. Don't go away.
Back here on News Central, and a reminder that we will be going back to the Supreme Court for live details as to the ruling and the way forward for Parliament in relation to the stay on the Speaker's ruling and declaring some 4 seats vacant. But for now, though, we're taking you up north to the Upper East region, to be specific, because there are other pressing matters in relation to the courts there as well. Some residents of the Bolgatanga municipality who arrived at the district and high courts have expressed disappointment with the closure of the courts. The Chief Justice Tuesday evening directed 7 courts in the Upper East region be closed down until further notice due to the security situation in the region. What's the security situation? The Boko tensions and the escalation of violence from there since the weekend, with more than 15 lives lost as curfew that's been imposed on the Boko township, and we've been bringing you details of it. That has resulted in the closure of court. Our Upper East regional correspondent Tanko Mohammed Rabiu is currently at the district court in the Bolgatanga municipality monitoring for us. He's joined us live via Zoom right now. Tanko, what can you report at where you are following the directives? We know there's disappointment by some individuals who arrive at the court today.
Yes, thank you very much, Mawina. I'm currently at the Bolgatanga High Court, following the directives by the Chief Justice for all these courts to be closed down due to security situation in the region as a result of the Boko crisis. Early this morning, when I arrived at the Bolga District Court, a lot of the clients who are having their case to the head and those who are coming for legal services were disappointed because they were told, they were told to come today due to adjournment yesterday at the court. They told me that they were not informed that this issue will happen today, so they came to court as usual. And then even when they arrived, the court were locked and key. No one was there to answer their grievances. So I had interaction with some of them, and then this is what they had to say.
Well, we are here this morning because we have a case here. So we were told yesterday to come here and judge, and the judge will pass the judgment for us. So because of that, we suspended everything of ours and appeared before the court this morning. So upon our notice, we came and realized that the whole place is locked and there's nobody here. And when we can call to find out, first one weekend we met one person here. He said that they are not working today, that there is some authority that says that because of the Boko conflict or something like that, they shouldn't work. So because of that, in fact, that's well our this. So I think that's the only way that it has affected us, because we have other duties somewhere that attend. But so far as court matter is very important. So in fact, it's really a worry because we should have been informed. We should have been informed so that we would have used this day for maybe other.
Tanko, thank you for those details there. That's my colleague Mohammed Rabiu Tanko from the Upper East region for us. Let's try and walk you briefly through the affected courts as was listed by that release by the Chief Justice, and that's on your screen right now if you're watching from home, or on your phone if you're streaming via Facebook or Twitter, now X, and the affected courts: the High Court in Bolgatanga, the Circuit Court in Bolgatanga, the District Court in Bolgatanga, the District Court at Zwarungu, another District Court at Zebila, and then a District Court at Garu, and then finally a District Court in Bongo. These courts have been closed indefinitely in relation to the tensions in Boko, and that's the latest. We've been hearing from persons who've been expressing disappointment in relation to it. We'll go for another break. We return with a bit more, and then we anticipate that ruling from the Supreme Court.
I'm Kemini Amano.
And I am Mawina Igbeta. The afternoon show is next on your television, but be informed, we're back here when the Supreme Court panel, 5-member panel, returns to deliver their verdict. We'll be here to provide you details of that. I am Mawina Igbeta.
Anyway, we'll see you soon. Bye-bye.